Well, welcome to the Hammond Iles Financial Power Hour. Today we're joined by a very special friend and guest. Cate Craig will be joining us to talk a little bit about estate planning 101, how to secure your future and protect what matters most to you. Just as a little bit of housekeeping as we get started, I just want to share that at Hammond Iles Wealth Advisors, we are a registered investment advisor, and by doing so, we do not provide tax or legal advice through our firm, and so we partner with individuals like Cate that do a wonderful job in their professional realm, and so we partner with them to better serve you and all of our clients that we are working with. So I also want to highlight that today's advice is informational and educational, as well as the fact that will be from a point of view of being here in Connecticut. So before you take any advice, it's important to talk to your own legal or tax advisor to make sure that you are using the appropriate laws or strategies appropriate for you personally, as well as the state in which you reside. So today we're joined by Cate Craig, who's an estate planning attorney with Reese Wilson Case. She focuses on estate planning, estate administration, as well as elder law and real estate. So we're happy to have Cate here after a long weekend of watching baseball with her three sons, and she lives with her husband right here in Wethersfield, Connecticut. So Cate, thank you for joining us, and we look forward to kind of hearing your insights on what we should all be taking into consideration for estate planning.
Great. Thank you so much. Thank you so much for having me. Thank you all for joining. As Greg mentioned, I am Cate Craig. I'm an estate planning attorney with Reed Wilson Case with offices in Middletown and satellite offices in Guilford and Wethersfield here in Connecticut. Today we will be walking through the essentials of estate planning, what it is, why it matters, and how you can take practical steps to protect your future and your loved ones. So when I do presentations like this, I always like to start off with my why. Why do I do this? Why did I become an attorney? Why did I become an attorney in this particular field? And the reason is that 11 years ago, I unexpectedly lost both of my parents. It was, as you can imagine, very devastating. I was a mother of a 1.5-year-old at that time. I was pregnant with my second son. I was not an attorney at this point in time, and I had no idea what I was doing. And unfortunately, the fiduciary roles for both of my parents' estates fell on me, and I had a really bad attorney. So I was not getting good advice, and I was not getting a lot of support. And as you can imagine, going through that grief that I was going through, and then having to navigate a process that I was unfamiliar with, while also dealing with, family and husband and life and all of that, it was a lot. It was a lot. And so after going through that experience, I decided, you know what? I think I can do this better. So I went to law school, and hopefully I feel like every day I do help someone. So that is my goal, and that is my why. And, not to start the presentation on a sad note, but I do feel like nobody ever thinks something bad is going to happen until it does. So I think what we can do is just prepare for the worst and hope for the best. And so that is why I am a huge fan of estate planning. And with that, I hope that when we go through this presentation, you can think of it as an overview designed to both give you some concrete action items to prepare for your financial well-being, but also to give your loved ones peace of mind that at the end of the day, they might not be in that same boat that I was in, kind of left to pick up the pieces for my loved ones that did not have an estate plan. So we can go to the next slide. So estate planning is not just for the wealthy or the elderly. A lot of times people will say to me, "Oh, I don't have a lot. I don't need an estate plan because I don't have a lot." It's not about what you have all the time. It's about where you want those assets to go, and sometimes it's about avoiding probate. So there's lots of reasons why you would do an estate plan. We'll talk about estate planning essentials, even if you already have a financial plan, some common mistakes that people make, and also how your attorney and your financial advisor can work together to make sure that everything aligns, because you always want to have an estate plan that works in conjunction with your financial plan. You don't ever want them to be in conflict with one another. So I work with financial advisors quite a bit for that reason. Next slide. So step one, what I would say about step one about estate planning is really kind of understand what your assets are. What do you own? Inventory your assets and really kind of come up, even do a spreadsheet, if that's what works for you. Come up with what you own, how it's titled, whether it's titled in your sole name or it's titled jointly with your spouse or someone else. See if you have beneficiaries designated on certain accounts. Make sure those beneficiaries, if they are named, are the ones you want named. So that's kind of step one. It's not just about property, it's about people, property, and planning. So inventory those assets, and then think about who would you want to be in charge of these assets should anything happen to you? Who would you want to inherit your assets should anything happen to you? Do you need to make changes to the people in these roles? Sometimes people name friends and then they have falling outs. And so now, you really want to stay on top of looking at your estate plan every 3 years or so to make sure nothing has changed. And lastly, do you have estate planning documents in place that legally reflect your wishes? So a lot of people will, in their mind, say, "Oh, this is what I want," but then they never get it down on paper. And people will come in a lot of times with unsigned wills for their loved ones. It doesn't mean anything. It's just a piece of paper. So unfortunately, you really have to get to the finish line, for lack of a better term. You have to sign your documents. You can't just draft them and then say, "Oh, yeah, I'll get around to it." Because most of the time I see people come in that say, "Oh, I never got around to this," or "My dad said he was going to do this, but he never did it." It's one of those things where it's really hard to get to the table to do it, but it's really important that you follow through with it. So I do like to take a little time in this presentation to talk about a client that I had a few years back, because at the bottom here you will see, hint, your will does not necessarily cover all your assets. And that is true because you might have assets that have beneficiaries designated. Those will supersede what you say in a will. But I have a story about a client that came in. Unfortunately, his dad had just passed away, and he had in hand a will that his dad had written himself. And he says, through our introductions, that my dad had 2 pieces of property. He has a house that I live in with my family, so his son and his family, and then he had a house that he lived in with his second wife. Well, in the will, this gentleman has bequeathed both houses to his son. So his son comes in and says, "Oh, both houses are mine. When can I get my stepmom out?" And through talking to him, come to find out that this gentleman had found out that his wife was cheating on him with a coworker. And rather than just confront her, he decided to use his will to get back at her and basically take the house away from her. Well, can anyone guess why that backfired? You might already be assuming. There are other ways to pass property, and one of those ways is through deeds. So one of the deeds, the house that the son was living in, was just in his dad's name. So yes, that house passed to the son. But the other deed that he lived in with his second wife that was cheating on him was held jointly with rights of survivorship. What does that mean? That means that upon his passing, that house automatically vested in his wife. And it was her house and her asset. So it did not matter what his will said. It mattered what the deed said. So takeaways. Don't use your will to get back at a cheating spouse. And 2, don't write your own will, because these are the common mistakes that people make when they try to take estate planning into their own hands. Estate planning attorneys have lots of stories, but that's just one interesting one that stuck with me. Next slide, please. So again, there's 3 pillars, right? We want to focus on the people who will make the decisions for us and who will be our beneficiaries. Property inventory, making an inventory of what assets we own, how they're titled, how they're going to be managed and transferred at your passing, and then planning. What can we do with an estate plan to ensure that our assets get to who we want them to get to? Next slide, please. So again, estate planning is not just about you. A lot of times people will come in and say, well, I'll be dead. What do I care? And that's probably one of the terms that I dislike the most, because it's not just about you. Yes, you're not going to be here, but the people that are going to be here are your loved ones. And they're the ones that are going to have to deal with whatever situation you leave behind. So our goal as estate planners is not only to safeguard your legacy, possibly avoid probate if that's important to you, but also ensure a smooth transition of your assets to your beneficiaries. Next slide. So if you do not execute a will, this is what is referred to as dying intestate. If you do not have a will, then the state steps in and the state law decides who gets what. And that might not be what your wishes are. So in Connecticut, if you pass away without a will, everything goes to your spouse. If you pass away without a spouse and you have children, it goes to your children. If you have neither and you have living parents, it goes to your parents. And if your parents are deceased, it will go to your siblings. That might not necessarily be what you want. So that is the reason why you would want to execute a will. I did put a little disclaimer down here about probate assets. We can go back to them, but basically probate assets are assets held in your sole name with no beneficiary. That's what would basically be distributed based on what you write in your will, or without a will, what the state would be distributing in an intestate estate. Next slide.
Kate, before you move off of kind of executing a will, I know one of the questions, even for me with 2 adult daughters, is what age do you think that someone should create a will? You know, so many people, well, I don't really own that much. I just have maybe a retirement account and some investments. Where do you think that the estate planning process should start for someone?
I don't know if it's necessarily an age. I mean, obviously you have to be 18 or older. You can't be a minor to execute a will, but I don't think it's so much, you know, your age as it is your assets, and whether or not your assets are all able to be non-probate assets, meaning you can name beneficiaries, so a will would not be needed. If you own real property, especially if you own real property in your sole name, I would absolutely say, yes, you definitely need a will. For younger kids, and this is something that we're actually focusing on in September, is kind of back to school month. A lot of people don't realize that once you turn 18, there's nobody that has legal authority to make financial or healthcare decisions for that child, right? Usually a child that's either in college or working, maybe still living at home. A lot of parents just assume, oh, well, I have that authority. No, actually, you don't. So in September, we're really trying to push at least college kids having a healthcare directive, which I'll talk about a little later in the presentation, to name an agent for if something happens to them medically and they can't speak on their own behalf. And then also a power of attorney if necessary, again, if they become incapacitated where they can't manage their own financial affairs. So maybe not a will, but definitely a power of attorney and a healthcare directive would be something we might want to look at.
Great.
Okay, so when you have a will, an important part of that is naming your executor, and that is the person that's going to handle your affairs. I always recommend naming successor agents on everything. So successor executors, successor agents on healthcare directives and powers of attorney for two reasons. One, what happens if something occurs where you both pass at the same time and you've named your spouse? Now you have no named agent. Or a lot of times your named agent will pass and you forget to go in and update your estate planning documents with another agent. So wherever you can name successors, definitely want to do that. So you want to be naming people, obviously, that are responsible, especially the person that you're naming as your executor, somebody that can pay your bills, distribute your assets according to your wishes, someone that can potentially work with a probate attorney and stay on top of things. Naming this individual will cut down on probate court and involvement in this decision, and could also reduce family stress because you've already named who you would like to handle this role. Next slide, please. So we briefly touched on probate assets. Again, so a probate asset is in Connecticut, an asset that you own in your sole name without a beneficiary designated. These are assets that will have to be probated in the state of Connecticut, and that is the legal process that you must follow to transfer property from a deceased person to the person that is eventually your beneficiary. The reason why people want to avoid probate in Connecticut is because it is oftentimes a very lengthy process. It can be anywhere between 6 months to a year. You have to wait for your executor to get appointed, which could take a couple weeks to months. And in that time period, it's this gray area where no one has control of any of your stuff. But that doesn't prevent people from calling you and asking you where the payment is for this, that, and the other thing. So your executor is stuck until they get that fiduciary paperwork saying, yes, I legally can act on behalf of this person that's passed away. Then that starts the process of doing an inventory for the probate court, filing your will with the probate court. Now the probate court has jurisdiction over the estate. You do have to, work, usually most people have to work with an attorney because there's lots of probate filings that have to be recorded with the probate court, and it can cost between $5,000 and $10,000 in Connecticut to probate an estate. So people don't like that. There's also a 5-month creditor period. A notice goes into the paper saying this person has passed away. Creditors, you have 5 months from this date to bring forth a claim against the estate. And in that 5 months, it's just stalemate. Nothing can happen. Distributions cannot be made to your beneficiaries, and you have to just wait and see if somebody comes forward with a claim against your estate. and an estate bank account has to be opened. And at the end of probate, a final accounting has to be done to show the probate court what money has come into the estate and what money has gone out of the estate. So some people are like, okay, my kids can deal with that, no big deal. Other people say, oh no, that sounds terrible. How do we avoid that? You avoid that with a revocable trust, often referred to as a probate avoidance trust, because that's exactly what it does. Most of the time, people's biggest hang-up is real property, because in the state of Connecticut, you cannot pass real property by beneficiary designation. So if you own a home with a spouse, not so much an issue upon the first spouse's passing. However, an automatic probate estate upon the second spouse's passing, because now the second spouse owns the home in their sole name. And if you own solely owned real property in Connecticut, you automatically have a probate estate. So what people do is they create a revocable trust, they deed their house to their names as trustees, and then regardless of who passes away first or who passes away second, the house is no longer a probate asset. And then oftentimes we can use the trust as we can retitle other assets, like financial investments in the name of the trust, or we can name the trust as the beneficiary, thereby avoiding probate altogether with all of your assets. So a little bit more money on the estate planning side to set this kind of trust up, but less money on the back end because you will not have to pay for probate. And that is attractive to a lot of people, including myself. I wish my parents had one. It would have made life a lot easier for me. You can go to the next slide. So I did want to briefly talk about irrevocable trusts. I could probably talk for another 2 hours about all the different types of trusts, but irrevocable trusts are commonly referred to as asset protection trusts because their goal is to protect assets. So there are trusts called domestic asset protection trusts. These are trusts designed to help shield people from creditors, lawsuits, financial risks. They are popular amongst business owners and people that are incredibly wealthy. You do have to sign legal documentation saying that you are, of course, not creating this trust to try to avoid some kind of pending lawsuit that you know is coming. So we can't think of it in that term. But for the most part, what we see in our practice is people coming in for Medicaid asset protection. And again, this is Connecticut, but I'm only licensed in the state of Connecticut. But what's happening in today's day and age is that we are living longer. So yes, that's great. But we're living longer, accumulating all of these assets throughout our lives, hoping to pass down to our beneficiaries. And then in the last couple of years of our lives, we're getting sick. And we're getting sick to the point where we need skilled nursing care, which at this point in time can be anywhere between $10,000 to $20,000 a month in a skilled nursing facility. So what's happening is all of that money that you have accumulated is now being completely spent down on your skilled nursing care. And now you have nothing left to leave your beneficiaries. So I would say 90% of the time, people will deed their home to an irrevocable trust. What that does is it starts a 5-year look-back period. After that 5-year look-back period has passed, any asset that you have placed in the irrevocable trust, it's like an invisibility cloak, falls over it. And no matter how much money the state has paid for your skilled nursing care under Medicaid, they will never be able to force the sale of your house for you to pay for your care, nor will they be able to lien your house to get paid back for care that they've provided you. So this is an asset protection strategy to preserve assets for your beneficiaries. In this type of trust, you are the settlor, but you are not the trustee. So you need to have an independent trustee. That could be your child, it can be anyone except you. Reason being is you have to create that distance between you and the asset, or the state is going to say, well, you have that house, sell it and pay for your care. So that's just a little bit about irrevocable trust. But like I said, we could talk for longer about that. But we have some other things to talk about. So we'll go to the next slide. So estate planning isn't only about money, right? It's also about health and dignity. And at Reed Wilson Case, we do everything on a flat fee structure here. And we do packages because we would never, well, I won't say never, but we would usually always encourage people to have a healthcare directive. This is a document that appoints a healthcare agent for you and a successor agent should you be unable to voice your decisions regarding your health and your health care. So a lot of times this could be a situation where you're in a coma-like state, or you've been in an accident, you're not conscious, so you cannot talk to the doctor yourself. You are naming an agent that can step in and be that person for you to talk to whoever your attending physician is. But in addition to that, the document also says what your wishes are in regards to life support measures, in regards to organ donation. You can put a lot of things in that document to help guide your agents so that they know what your wishes are. They're not left guessing what is the right thing, what's the right call to make. This document gets confused a lot with living wills and DNRs. They are not the same. A living will is usually just a document that kind of broadly says that you are not intending on any direct taking of your life, but that you don't want your death to be unreasonably prolonged. There are no agents named. A DNR, of course, is a do not resuscitate. That's usually a document that they push at you at the hospital that basically just says, if I flatline, don't take any measures to try to resuscitate me. So that's the difference between an advanced healthcare directive, a living will, and a DNR. Okay, next slide. Something that we also do in our healthcare directive is we nominate a conservator of person and estate. So a conservator would be needed if for some reason you have lost the capacity to care for yourself or to manage your finances. Again, this is often seen in situations with dementia or Alzheimer's type of situations. And a lot of people do not realize that anyone can petition to conserve you. So that's a little scary. I always reference the Britney Spears situation. So if you can execute a document saying, if this is ever the situation, this is the person that I would like to be able to conserve me. And then again, we always want a successor. That is a much more difficult hurdle for somebody to come in and object with a probate court judge, because when you were, had capacity to do legal documents, you named the people that you would want to have this ability to conserve you. Next slide, please. Okay. So power of attorney, briefly talked about that as well. This again would be a document that we would recommend everybody does. It is a very important and powerful document. If you become incapable of managing your financial affairs, no one would legally be able to help you without a power of attorney. Again, we want to name an agent and a backup agent. And basically, without having this document, it might be a very costly, time-consuming court process just to have somebody help you pay your bills. A lot of times when someone does not have a power of attorney signed, we end up in probate court trying to get a conservator appointed. So it's better to do the power of attorney now. And also, it's not only in a situation of incapacity, mental or physical incapacity. A power of attorney can also be used in an emergency situation. So let's say you're on a Mediterranean cruise and there's some emergency that happens. You need your power of attorney to wire you money. They can do that with this document. I will say that it's only a living document, so once you pass, it does not mean anything, and banks will only accept originals. So sometimes people get a little, nervous about having the original floating around in their house. So at Reed Wilson Case, we always offer to keep original estate planning documents here in our fireproof safe, and if an original power of attorney is ever needed, we can make that available to your agent. Next slide. So there's two types of powers of attorney. I'll just briefly mention them because I don't often do springing powers of attorney. Immediate, it's exactly what it says. As soon as you sign it, that agent has the authority to do all of these things for you. They can take money out of your bank, wire money for you, do your taxes. They can talk with all of your financial representatives. Some people, again, they get a little nervous about that. So they go to a springing power of attorney. The springing power of attorney will have language in it that says that this document only takes effect upon a certain happening, a certain event. Usually that event is incapacity. Next slide, please. So the reason why I don't like springing powers of attorney is that you have to prove incapacity, right? So in an emergency situation, you're kind of roadblocking what the point of that document is. Usually it is two independent doctors and a probate court judge that will have to agree that you're incapacitated in order for your power of attorney to step in. A lot of times people will say, oh, I have a power of attorney, and they bring in their documents and it's from 1990. I will say this is not legal in the state of Connecticut, but no bank that I have ever seen has taken a power of attorney that is any older than maybe 6 years. I have been on the phone many times with bank supervisors saying this is not legal, you have to take this document, but they will give you a hard time if it is old. So we generally like to say if it's stale within 5 to 6 years, you want to update it. Not because you legally have to, but because a bank's going to give you a big to do if you try to use one that's older than that. And I mean, I understand, if you're coming in asking to take a bunch of money out of somebody's account and it's old, the banks are liable. They get nervous, but it's not legal. Next slide. So who decides if you're incapacitated? Well, it depends. Usually, like I said, it's two independent doctors and a judge. But if you have a signed power of attorney, that is an immediate power of attorney. The agent that you name has immediate authority to act as your power of attorney. Okay, next slide. All right, so this is fun dinner conversation, but it's another document that I do have to mention because it is important and it is part of the package, if you will, that we do at Reed Wilson Case. It's called a disposition of remains document, and what it does is it names an agent, and again, a successor agent, that can have your remains released to them wherever it is that you pass away. In this document, you can also specify what your burial wishes are. And a lot of times your loved ones don't know that unless you've told them or you've written it down, and it's not in a legal document. But I do find that sometimes family members do not agree on this. Some might want cremation, some might want burials, some might want a celebration of life ceremonies, some might want a full Catholic service. If you do this agreement, not only are you making sure that your wishes are known and followed, you're also cutting down on that possible family conflict that can come in if people don't agree, which was actually the case for me. And if my parents had had this document, I could have just waved it in my brother's face and said, nope, we're doing this, but they didn't. So that is another document that if you can execute, I would say go ahead and execute it. There's, in my opinion, there's never too much information that you can provide to your loved ones as far as estate planning goes. So that would be your funeral and burial wishes, also known as disposition of remains documents. Next slide, please. So why estate planning matters? You know, estate planning really goes hand in hand with financial planning. Together, they can avoid probate entirely, reduce estate taxes if you have a taxable estate, which is $13.99 million currently. So good news for some of us, bad news for others, depending how you look at it. Provide business succession plans. I often see this as a very overlooked part of estate planning. People that own businesses, what happens to your business if something happens to you? It seems like the last thing that business owners think about, which is surprising to me. Protect assets from creditors, and you know, it's about control, protection, and peace of mind in a nutshell. Next slide. So again, common mistakes people make when estate planning or deciding not to do an estate plan. Thinking that you don't have enough, or I don't have anything. I can't tell you how many times someone has done a beautiful revocable trust, and then their son comes in or their daughter comes in and says, oh, I found this account with $1,000 in it in my mom's name. Okay, is there a beneficiary? No. Well, now you have a probate estate. Okay, so we don't want to ever be in a situation like that, because now you have a $1,000 asset that you have to pay way more to probate just to close it out. A lot of times that does not make any financial sense. Other issues, not updating documents after major life events. So what are these major life events? Marriage, divorce, buying property, starting a business, birth or adoption of a baby, a death. These are all life events that you should be thinking about, okay, what do I need to do, if anything, to my estate plan? I have lots of stories, but I will just say this. I have been on the receiving end of wife number 2, learning that her deceased husband never took wife number 1 off of the life insurance beneficiary form. So things of that nature do happen. Just make sure that you are reviewing your estate plan at least every 3 years. And we send out reminder letters every 3 years, but those kind of big life events are when you want to kind of do a little health check. Let's see. Also, waiting too long and not having the capacity to sign. Unfortunately, if I determine that you lack capacity to sign legal documents, I ethically am not allowed to execute them for you. So I do have people bringing in their elderly parents, asking for me to do an estate plan for them. If you are in a state where you don't know where you are, you don't know what you're doing, you're not understanding the documents that you're signing, you cannot sign them. So waiting is a big mistake that people make, and then they try to kind of double back to fix it. If you've lost capacity to sign legal documents, the only way that you can help that person is through petitioning to be their conservator, which again is a core process that is costly and time consuming. Don't forget about your digital assets, crypto accounts, online accounts. Make sure that you have beneficiaries listed on those. Again, I mentioned, succession plan for business owners. That's a big one that I see. And again, making sure that your estate planning documents work in conjunction with your financial plan. Next slide, please. Okay, so strategies for preserving wealth. We can use trusts for asset protection and tax efficiency. You can do some charitable giving or do some philanthropic legacy planning. We also do business succession buy-sell agreements here. So making sure that something happens to you, your business, either someone's going to take over or you're going to give somebody the ability to make the decision whether we're going to liquidate all of the business assets or we're going to try and go find a buyer for this business. And then again, coordinating estate documents with financial accounts and investments. Next slide, please. So action steps for all of you joining us today. What can we do? One, inventory your assets and decide who will act in those fiduciary roles for you, and who are your beneficiaries. This often takes up the most amount of time, the most discussion, and we work on your timeline, right? Most of the time when I do my consultations, a lot of times people don't have these answers, and that's okay. You have to go home. Maybe you have to call somebody and say, hey, would you be willing to take care of my children if we both passed away? Those are conversations that you have to have. They might be difficult, but they are important. So, again, naming guardians for minor children should something happen to both parents. Schedule a review with your financial planner and your estate planning attorney, which hopefully if you're in Connecticut will be me. Update or create key estate planning documents. So very happy to always look over documents that you already have in place. I do that often in my consultations. I am not going to tell you that you need to redo a document if you don't. And I'm very happy to look at documents that someone else has executed with you or drafted for you, and make my suggestions if I think that something needs to be changed. And then again, review your plan at least every 3 to 5 years, or if there's been some kind of major life event. Next slide. So disclaimer, because I am an attorney after all, right? We love to just throw those disclaimers in there. So you can read this. I don't have to read that for you. But that's our little disclaimer. Next slide. Here is our contact information and our addresses. You can follow us on social media, or check out our website. There's lots of information there, including my bio. We are an all-female firm, owned and operated. Just kind of happened that way. Nothing against the fellas. We love you too, but we are an all-female firm. So please visit us at our website and learn more about us and why we love what we do. Next slide.
Right, so now it's my chance to just say a little bit about what we do, and thank you, Cate, for taking time with us to go over estate planning 101 and kind of just the basics, as well as good reminders for all of us to go back and revisit. Certainly that 5 to 6 year time frame tends to slip by very quickly. So you got me thinking I need to go back and look at my own documents as to how long ago were those power of attorneys put in place. So it's an important reminder for all of us. And for those of you that may not be clients of Hammond Iles Wealth Advisors, as Cate mentioned, it's always helpful to have a team that works together both on the legal and financial side of things. And if you would like a free conversation with a financial coach at Hammond Iles, you can either scan the QR code or go to our website at hiwealth.com. One of the things that sets Hammond Iles Wealth Advisors apart from other financial planners is we have no minimum investment amount. We focus on working with families across multiple generations. And so our youngest client to being 10 years old and through their grandparents and great-grandparents. So we have worked with families across multiple generations. We believe everybody starts from somewhere, and so we don't set a minimum investment amount. We have online financial power hours like today's that will be recorded, and you'll find all of those on our YouTube channel. And so we encourage you to follow, connect, or like us on social media, as well as there are some additional resources on the Hammond Iles website, one of which is 20 things to make sure you do when a spouse or loved one passes away. Also, when we're talking about legal documents, Cate mentioned about the importance of keeping those in a spot where they're readily accessible and able to be used, whether that's with your attorney or safely in your home. One of the other benefits that we offer to our clients as part of our Hammond Iles financial portal is that there is an online vault that you're able to scan and upload your legal documents. So if you're traveling or if something, God forbid, happens suddenly, then either your family members or your spouse has the ability to access those documents remotely to be able to handle any matters that could be addressed or need to be addressed. So here is our contact information. And as we wrap up today's workshop, I encourage you to keep an eye on our website for upcoming topics.
Thank you so much. I appreciate you having me.
It's my pleasure, Cate. Thank you for taking time out of your day. And for all of you, thank you for taking time to join us as well. We wish you well and enjoy your afternoon. Take care.